told Jamaica, it states that we live on an Atlantic hurricane belt with 5 fault lines, which exposes us to natural disasters, of which include earthquakes, hurricanes, tornadoes. And as a result of that, I find this theme very topical, because the law is an engine that drives legislation and drives policy. And it is important that persons are educated and informed, and construction is built in accordance to legislation that looks at the challenges that we can face in where we are located as an island. So this week's clinic will focus on charting a sustainable future for all by exposing and educating persons in the community of the importance of proper legislation to guide a sustainable future, considering where we are located in the global sphere. So with that, I'll now introduce my colleague and my principal at the bar, who will come with his own address, Dr. Christopher Malcolm. Join me in welcoming him to our Norman Manley Law School Legal Aid Clinic Fair.
Good afternoon.
Very good afternoon, also for hearing the proceedings this afternoon. And also look in the audience to say, welcome Mr. Bassie, who is the guest speaker for the afternoon, and Director, Mrs. Wisdom Barnett, and to all the other persons who are here with us live, and to everyone online. Thank you for making the time, and more importantly, for committing to sharing with us in this legal aid.
Norman Manley Law School Legal Aid Week, which will culminate on Thursday, with an open day here at the Gibraltar facilities of the Norman Manley Law School, where the Legal Aid Clinic is located. We expect it to be a wonderful occasion, and we expect everyone to be here. Now, Ms. Cruikshank just indicated the conference theme, which is Law, Sea, and Me. And I will stop there for the minute. And the important thing about that is that, as I sat and I meditated a bit on what it is that I had to say, I reminded myself that we are on an island. Jamaica, however, many do not remember we are an archipelagic state. We're not a single island. We have several offshore keys and other islands as well. And we're part of that. And we find ourselves in a strategic position where we're able to leverage our resources and be a big part of the blue economy, which has become so important over time. Now this week, as we look at the theme and look at issues coming out of it, we get an opportunity to reflect on where we are, literally, which is in the middle of the Americas, north, south, and everywhere else. We're literally, geographically, in the middle of it all. An interesting time that we're in, all sorts of matters happening around us, persons questioning whether international law, for example, is still relevant, whether international relations as we know it is still relevant. And in all of that, we have to live with domestic matters relating to how do I prepare for my future? How do I deal with succession planning? How do I make a will? How do I transact business in the selling of land, the conveyancing, and so on? How do I ensure that if I'm building in a manner which is compliant with local regulations? How do I ensure that if I get into problems, I understand how to resolve those, including by reference to, and Mr. Bassie, I'm sure will speak a bit about that, alternative justice streams, mediation, arbitration, adjudication, and so on, or going ultimately into litigation if that is where you go. How do we prepare ourselves adequately for avoidance of these processes? How do we ensure that when we put our arrangements together, we do so in a manner that allows us to leverage what we have, get the best out of them, and then ensure that if at all there are problems, we understand them well and we understand how best to deal with them. How do we get all of those things done? Unfortunately, I can say for those who are listening and will listen throughout the week and those who will attend, that the Norman Manley Law School Legal Aid Fair is the place to be this week. Because those matters are matters which will be considered, and you will be among persons who understand what you're speaking about, who are ready, willing, and able to provide assistance, ably supported by our young interns, or our interns, meaning our young lawyers in training, not yet qualified but soon to be, who will also be here to hone their own skills and to pass on of their knowledge and to be able to provide support with the appropriate guidance of their tutors. So this is an event not to be missed. It's an event which we are asking you to spend some time, not just to be with us, but to be with us to provide your support, to share. And we are always willing to take guidance and support from others. We're always willing to expand upon what we do with your support for the welfare and good of our Jamaican people, and in fact for our Caribbean people. We serve the region. And so this week provides us with an optimal opportunity to find out what is happening here at the law school, and in particular at our legal aid clinic, and to see how it is that you can benefit from what it is that we provide. But importantly as well, how it is, for example, as a corporate entity, you might find it appropriate to collaborate with us and to enable us to do more as we provide support to the publics, not just the public in a very narrow way, but the broad publics that we serve. Please be with us, please make time to share with us, and give of yourselves as we do to you in support of making Jamaica what it can be, the best place to live, work, retire, and do all the wonderful things that we've pledged that we wish to do. Thank you again for your time, and I now officially bring this fair into order. I officially declare it open. Thank you for your time. Thank you for your support.
Thanks, Master Principal. And at this time, I'm going to introduce Mr. John Bassie. At this time, I'm going to introduce the Director, Mrs. Lassie Wisdom Barnett, the Director of the Norman Manley Law School Legal Aid Clinic, who has put in all the work to make this week, the Legal Aid Clinic Week, and the fair a success. Welcome, Mrs. Barnett.
Good afternoon, everyone. Good afternoon for those who are here in person and for those who are sharing online. It is my privilege to welcome you all to the launch of our Legal Aid Clinic Fair. And why are we doing this? Why did we put in all this effort? The Legal Aid Clinic, as the practical training arm of the Norman Manley Law School, our mandate is to uphold the rule of law. And so all that we do pours into this matter of training our students, ensuring that we're providing public education as well, and additionally legal services to members of the community who are unable to afford the usual services of an attorney at law. And so all that we do, the training of the students, the public education exercises, and ensuring that legal aid services are affordable, pour into this week of activities where you're able to share And it is important that our graduates recognize their duty when they leave here to continue to engage with members of the public, as they too, in practice, will be called upon to offer legal services. The fair each year is part of our offerings, and in addition to our legal aid fair, we also have a number of student outreach activities. And this year, we're doing things a little differently because our students are participating in the fair as an outreach project for some of them. And so you will notice that as we go throughout the week, there will be many occasions where the students will be up here taking charge. And so we're looking forward to that new challenge this year and the way that it's going to be delivered by the students. The clinic facilitates engagements such as this activity each year to ensure that there is a meeting and an opportunity for meeting between our stakeholders and the key organizations which provide legal and social services and who help to safeguard the members of the public. As we focus our attention on law of the land, sea and me, charting a sustainable future for all, we are reminded that this is a time of increasing challenges. It's brought on by climate change, population aging, behavioral changes, and we see the need to continue our examination of the matter of sustainability and the law. The pandemic and recent natural disasters point to the need for better city and town planning. Incidents of piracy on the high seas, challenges with the water level in the Panama Canal, and the most recent turmoil in Caribbean waters with the unaliving of persons in small boats points to a breakdown in international maritime law. We are being threatened with the inability to fish, or importation of goods, and access to fuel is challenged. And so we are called upon to question whether or not the very law that we rely on is unsustainable. Our baby boomers are now senior citizens, and they are senior citizens in a time where there's an increasing cost for goods and services, where they have to navigate the Internet of Things and technology in a period where there is increased cybersecurity risk and incidents. And there's so many challenges all around to sustainability, not just on the land or the sea, but as individuals, as we all contemplate our future together. We hope that this week we'll be able to bring some clarity on the way forward. Thank you.
Thank you, Mrs. Wisdom Barnett. That was quite enlightening and informative. And remember, this week, the Gibraltar campus of the Norman Manley Law School Legal Aid Clinic is the place to be. We're now going to welcome our guest for this afternoon, our guest speaker, and one of my colleagues, an intern law student, will now introduce him.
All protocols observed, it is my distinct pleasure to introduce our next presenter, whose resume, at least whose achievements, is more like a resume and more like a passport. For over 2 decades, Mr. John Bassie has practiced across the Caribbean, North America, the United Kingdom, and Africa, bringing with him a rare combination of legal firepower and dispute resolution expertise that only a few can match. He's a UK barrister, an attorney at law admitted in Jamaica, a justice of the peace, and a management accountant. But what truly sets him apart is his mastery of the space where conflict meets resolution. Mr. Bassie is a fellow and chartered arbitrator of the Chartered Institute of Arbitrators, the gold standard in the field, by the way, and holds certification as a mediator in both Jamaica and the state of Florida. He has been appointed by the Supreme Courts across multiple jurisdictions to serve as a mediator, a testament to not just his credentials, but to the trust that the bench itself places in his judgment. He has served as Vice President of the Jamaica Bar Association and Vice President of the Chartered Institute of Arbitrators, and continues to shape the next generation of ADR practitioners. Today, Mr. Bassie turns his attention to a question that sits at the very heart of our legal order: how mediation and alternative dispute resolution can serve not merely as a shortcut around the courts, but as a genuine pillar in sustaining the rule of law. Please give a warm welcome to Mr. John Bassie.
Good afternoon. Yes, I've got my work together. Thank you so much for that warm welcome. I want to congratulate Principal and you all on this wonderful conference and the approach you've taken. And that this seems to be something that's at the heart of where we're all going as a people and the world. Slack correction. Past President of the Bar, past Global President of the Chartered Institute. Thank you very much. I appreciate the work that was done. This afternoon, I've been asked to speak about the rule of law with respect to conflict resolution, dispute resolution. So we're going to have a little discussion here. Are we streaming at the moment? Yes. But you who are here with me, if you want to participate, I'm okay. Just a little thing to get our minds going. Looking this up. Can any of you guess what the set of numbers are in front of you? Those in the audience. That's what you feel there. What do you think these numbers represent? And no, it's not a lot of numbers to see. Take a look. You take it? 42, 67, 13. Google it. Google it. Google free zone this afternoon. In fact, 42 is approximately the number of judges. Okay. "42 is approximately the number of judges in the Supreme Court level. 67 is approximately the number of judges at the parish court. And 13 represents approximately the number of judges in the Court of Appeal. So, what is Jamaica's population? Speaking? Come on, you must know that. What's not picking up for you? 2.7? All right. Approximately 3 million, yes. So, our population is approximately 3 million. Any thoughts? Look at that ratio. The number of judges and the size of our population. Just ask yourself, is it really possible for a judicial system in this respect to manage a caseload effectively? Right, so let's talk a little bit about the origins of alternative dispute resolution in our court systems. ADR is nothing new to us. This is something that you see, that you read in your history books, that elders in Africa the North American. Okay. North American Indians, number of different groups have practiced types of ADR throughout history. Roman law incorporated matters that were similar to arbitration. In fact, a formal agreement to submit to arbitration was recognized in Roman law. And of course, during the 1700s and 1800s, merchant law talked about ADR as well. We moved to the 20th century, and of course, labor arbitration, conciliation, and other forms started to rear their heads. So this is something that, despite resolution outside formal courts, has existed in virtually many civilizations, in many early societies. Now, the rule of law is not self-executing. It depends on effective mechanisms for resolving disputes. If courts are inaccessible or overwhelmed, the promise of legality weakens. ADR must be therefore assessed not as an alternative to law, but as a part of the architecture. So we all understand what ADR means, right? Alternative dispute resolution. And as people normally coin the phrase, appropriate dispute resolution. Because it's not one size that fits all. And you'll see as we go along that ADR ought not to be used in silos. Once upon a time, there's a school of thought, you use this, that. Nowadays, it's a little bit different. Justice delayed or inaccessible undermines the rule of law's credibility. And drawing from classical and modern theories, the rule of law requires predictability, equality, and enforceable remedies. Without mechanisms to vindicate rights, legality, it becomes symbolic. Would you agree with me? Okay. Next slide. Rights and remedies. Rights require remedies. And of course, we know that delay undermines legitimacy, and enforcement sustains trust. So these mechanisms that we're going to be discussing and looking at underpin the rule of law, and ought to underpin the rule of law. Now, I want to make it very, very clear. Litigation more than has its place. It's important. And some things need to play out in court at the highest levels. But not everything. Dispute resolution matters because the rule of law depends not merely on the existence of rights, but on the availability of effective mechanisms to enforce them. The legal system derives its legitimacy from its ability to resolve conflicts fairly, efficiently, and predictably. Without accessible and credible process for settling disputes, rights become illusory. Social tensions escalate, and confidence in legal institutions diminishes. Effective dispute resolution therefore sustains legal certainty. It preserves social order and reinforces public trust in the justice system, making it foundational rather than incidental to the rule of law. So therefore, I'm putting it to you that access to justice is critical. I can't overstate that. And I'm also saying the legal system cannot, as it exists, sustain effective, efficient, time-efficient resolutions all the time. But now, by way of some background, I would like to take a brief look at the historical perspective of ADR here in Jamaica. When we mention the dispute resolution of Jamaica, now this is a shameless plug because I'm the chairman of the dispute resolution. So I take a license here. Okay, Principal? Okay. Right. When we mention dispute resolution in Jamaica or the Caribbean region for that matter, the name the DRF, affectionately known, must be referenced. Our DRF is celebrating 35 years of service this year to Jamaica and the region. The DRF was born out of a collaboration between the Jamaican Bar Associations, the judiciary, the private sector organization of Jamaica, Ministers of Justice and National Security and Education, and the Capital University in the United States. The DRF was formed in 1989 and incorporated on July 11, 1994, with a mandate to promote and sanction the use of more non-violent ways of resolving disputes in Jamaica and the wider region. The DRF is honored to be recognized with introducing ADR to Jamaica. It is regarded locally as Jamaica's primary ADR consultant, training entity, as well as service provider. Regionally, it has been the go-to entity by our Caribbean sister entities for training and discussions centered around ADR topics. This is an area we freely share our wealth with. It's one of those organizations that it gives. We give to our sister organizations in the region. And I dare say, anywhere in the region, if you see ADR, existing mediation, RJ, the DRF has had its footprints there at some point or the other. So it's something that we as a region need to be proud of. I know we stand strong in our ethical position in terms of what we've learned over the years to share globally. And of course, we may travel and speak fondly about what we've done here in the region and what we've learned. So, institutional development in dispute resolution is reflected in the roles of the Dispute Resolution Foundation, the Supreme Court and the Ministry of Justice. The foundation supports training and accreditation. The Supreme Court integrates ADR through court annex mediation and judicial oversight. And of course, the ministry provides a policy and legislative direction. Together, these actors demonstrate that ADR is formally embedded within the justice system, our justice system, and contributes to legitimacy. Now briefly, on the Jamaica Civil Procedure Framework, mediation is often encouraged or directed by the court. This serves several rule of law objectives. Firstly, it reduces the backlogs of the Supreme Court. Secondly, it promotes faster dispute resolution actions. Thirdly, it encourages voluntary compliance, reducing enforcement strain, and it also enhances access to justice, particularly in civil matters. That access to justice rearing its head again. When courts are overwhelmed, justice delayed risks becoming justice denied. ADR helps preserve institutional legitimacy. Now, I want to pause for a second. And let's get real. Parish courts were overworked, and you'll see. Persons who access the courts, a lot of them are people of modest means. And really, but they don't even have bus fare to get to court, much less hire an attorney. Yet they want their day in court. They should have their day in court. ADR, as you see, that sort of mechanism that provides them access to justice that they seemingly they can't get. ADR began as an alternative litigation, but it is now embedded within our civil procedure rules across jurisdictions. Its growth reflects systematic pressure on the traditional courts. What do I mean by that? Courts, as they evolve, or as they begin to evolve, they start to use these dispute resolution techniques more. They start advising people at the lower courts, you have the option to do it. In fact, now, in our parish courts, if you can't afford a mediation, you can get a mediation. The government will pay for it. They'll pay the mediator to do it. That's a big thing. Because a lot of persons there just want to have their say. and of course modern systems treat ADR as complementary. The courts increasingly are mandating or encouraging mediation and recognizing that the judicial authority is strengthened, not weakened, by these pathways. And a lot of us must seem to forget, but we ought not to forget, access to justice is a constitutional value in many systems. Where litigation is prohibitively expensive or delayed, ADR provides that meaningful access. Now, the Jamaican justice landscape has been shaped by persistent court congestion, cost barriers, and procedural delays, all of which affect timely access to justice. High caseloads place pressure on judicial resources, while the financial and emotional costs of prolonged litigation can deter individuals from pursuing legitimate claims. The stress of going through a court proceeding can be so much. These challenges have prompted ongoing justice reform initiatives aimed at providing efficiency, expanding alternative dispute resolution mechanisms. Now I'd like to turn our attention to some of the main mechanisms that are at our disposal in our jurisdiction. The main tools that come to mind are mediation, which is our main focus here today. However, other mechanisms include arbitration, restorative justice, conciliation, and even plain negotiation. These processes provide structured, often less adversarial means of resolving disputes outside of litigation. What is mediation? Any takers? Let me ask. Yes, please. Name? Ms. Edwards.
Mediation is where both parties agree to hear each other's issues and come to a conclusion as to how we can go about solving this matter.
And what's critical to that conclusion, to that meeting?
It's where what is critical is that we agree.
Okay. Very good, very good. And you have a third party neutral that facilitates that discussion. So mediation is a method of resolving issues between two or more parties without resorting to litigation, and makes use of the neutral third party, a mediator, who helps guide the process to the dispute towards a solution that we can all agree, or they can all agree. Now I want to consider mediation in depth because as an ADR mechanism, it has had a powerful positive impact on our society. And if we look carefully, a lot of the soft skills learned in mediation can be found throughout all of the ADR mechanisms, such as effective listening, ensuring neutrality, and a fair, transparent forum. What are the key benefits of mediation? Mediation provides us with an option to improve the pace of conflict resolution. As such, it assists in reducing the backlog of cases. It offers a cost-effective means of resolving disputes, and we all know that time is money. Yeah. If we can have a dispute resolved on a timely basis, this transcends not just saving the parties money, but it also saves our judicial system, our economy, and society on a whole. The parties are able to create their own legal solutions, and own them in a flexible and somewhat informal environment. And one of the beautiful byproducts of this ADR tool is that it allows and sometimes assists greatly in allowing and saving valuable relationships. So, mediation is a tool that allows persons to come to their own solutions. They own it. The mediator facilitates a discussion. The mediator doesn't tell them what to do. The mediator guides them, allows them to hear each other. So it's really a beautiful thing. Community mediation. I talked to you about not working in silos. So you have mediation and you've got restorative justice. Now, restorative justice is a form of mediation, but it centers around a victim and the person who actually caused the issue. So we have a situation whereby these community-based mechanisms prevent minor disputes from escalating and preserve social order and reinforces confidence in our legal norms. So persons are able to come together, sit and discuss what their issues are and try and resolve them at that local level. Very critical to our society. And why is it critical to our society? Because once you start saving the court system time, energy and money, it translates into dollars and cents. This is the accounting side of my head coming into play right now. If you know that a particular case can cost 2-3 million, whatever it is, but if you're able to cut it short before going to the full end, imagine how much money you're saving the system. These things are real dollars. Community mediation addresses everyday disputes, such as neighbor conflicts, family disagreements, and minor civil matters, just before they escalate into formal litigation or violence, by providing a structured yet informal forum for dialogue. The DRF plays a central role by training mediators and maintaining standards and facilitating this sort of mediation service across communities. A lot of communities in most parishes now have this informal community approach. And it's championed also by the Ministry of Justice. There's a lot of RJ work. Of course, the mediation work is done by the DRF, and hand in hand, they're able to resolve quite a few disputes. Court annex mediation. It's a form of alternative dispute resolution as well. It's embedded directly into our civil procedure rules. In the parish court, you are offered a mediation. Judge might say, would you like a mediator? And nowadays, the mediators are on hand at the courts. So they're able to deal with the issues there, right there and then. It's my understanding that the backlog has really dropped, almost to zero in the parish courts in a lot of the parishes. So it's been rolled out. It's called a 12-month program. It's been rolled out across the country now, and the DRF is the one who's administering it. So it's really making a difference. Of course, our civil procedure rules have recently changed, but it's also offered at that level. The good thing is this, is that even though it's not an automatic referral to mediation, persons, because it's been around for so long, are asking for mediations. The lawyers are asking for mediations, the litigants are asking for mediations, and you'll find that our use of mediators has not dropped at all. One civil procedure prioritizes early case management to ensure efficient, cost-effective dispute resolution. And the judges are actively requiring parties to consider, or in many ways, prefer cases to mediation at the initial case of management. Why? Because if you can get the parties to resolve once again at an early stage, it saves the court system time, energy, and money. The DRF administers mediation cases on both the parish court and Supreme Court level. It's also important to recognize that non-court referred matters are handled by the DRF as well. If you want a mediation and you can't afford it, don't tell anybody I told you this, go to the DRF. They will give you a mediation, all right? It's not a secret. We don't tolerate people for mediations. Yes, you may have to go through a means test, but you will certainly get a mediation. Oh, go back. Conciliation. What's conciliation? Any takers? Conciliation is a dispute resolution mechanism often used in labor matters. If you go to the Ministry of Labour, or you take to the Ministry of Labour to discuss as council a matter, you will, at the first instance, be given a conciliator. The difference between a conciliator and a mediator is that the conciliator will suggest issues, suggest remedies, advise the parties, were this to be referred to the Industrial Disputes Tribunal, this may be the outcome. Mediator doesn't do that, but a conciliator has that sort of latitude. So conciliation is a powerful tool in our labour matters. Let's talk a bit about arbitration. Jamaica's Arbitration Act of 2017 is based on the United Nations Commission on International Trade Law. That is very powerful. It's a tool that allows us to stand on the global stage and say, hey, we've got an UNCITRAL-based law, we're modern, you can get your orders enforced. It's a big deal. And I'll tell you this, your principal, Mr. Christopher Malcolm, championed that. Here, you need to give a round of applause. Chris and I go way back. Arbitration was once one of those things that was really pushing it, and it still is. But Christopher realized the need for us to get this done, and he got it over the line. It really was good for Jamaica, and it's a long-lasting milestone for us. Restorative justice, RJ. When we speak of the mechanism RJ, we should be aware that restorative justice is both a set of practices and a broad philosophy with applicability across contexts. Restorative justice, I'm going to call it RJ, has several core philosophical features, including a focus on identifying needs and repairing harm, active accountability centering on relationships and community and voluntary participation. RJ is one of those tools that really has a profound effect on persons' lives. When harm is done, you may think, oh, this hurt that person. It affects the entire society. So if we can all I'd like you to do some research in your own. Google that. You can Google that. That's good. It's really an excellent tool, and it's a tool that, you know, we shouldn't just turn our heads away. Oh, I can't understand how that works. It works very, very well. And it also works with mediation as well. You may find an issue between a family member who has caused physical harm to another family member, but also there's a part of mediation in there. They work together to resolve the issues. Powerful tools. Negotiation. You'll find in your contracts these days, the dispute resolution clause is no longer matters referred to arbitration. No. What you'll find is that parties will say things like, we agreed to good faith discussions and negotiations. Failure to do that, we'll move on to mediation. A mediator will be chosen by Dispute Resolution Foundation or the Bar Association. Failure to distill those issues, we'll move on to arbitration. So there's a cascading effect before you run into court. And I'm really surprised how well that works. So negotiations at the bottom of it. And it's not just about contracts or business, it's in our very daily lives. Every one of you. I would advise you, if you're able to do the mediation course, no, not able, do it. You'll find out things about yourselves you never knew. We all have internal biases. Yes, we do. We just don't recognize them, we don't know them. And I'm mandated with Dispute Resolution Foundation to put together a student fee for doing dispute resolution, for doing the mediators course. So hopefully, you know, that will be rolled out very, very shortly, and we can get as many students in to understand this. Because once you start to understand how you resolve disputes, your life changes. Really. Okay, we talked a bit about how ADR expands access, lowers the cost, informality, speed and flexibility. And of course, efficiency in judicial economy. By diverting suitable matters, ADR allows courts to prioritize their constitutional and criminal matters, thereby strengthening our systemic capacity. Now, studies actually suggest that mediated settlements often achieve higher voluntary compliance, reducing enforcement burdens on the state. What do I mean by that? When people agree to do something and recognize the fact, I haven't gotten everything that I wanted, but I can live with this, they're more likely, who said it? Comply, right, and sustain. And you can, and actually what happens out of that too, in most cases, develop the relationship. I can't tell you how many times I have been in dispute resolution matters, mediations, arbitrations, what have you, where persons just didn't take time to listen to each other. Okay. It's okay. The UNCITRAL model law I just mentioned to you has harmonized arbitration standards globally, promoting consistency. I want you guys to understand that this particular model law allows parties throughout the world to harmonize, enforce their awards, and recognize that that place a place to do business. When people come to our country or jurisdictions, first thing they want to know is, how are you going to resolve my disputes? You say, well, we don't ever wait till 4 years before you get a trial date and thing. No. Do you have arbitration? What sort of arbitration law do you have? You'd be surprised. These things make it a place to do business. ADR and legal certainty. It predicts enforcement, stabilizes transactions, and reduces risk. These are all important things for anybody who's doing business. And not to mention democratic governance. ADR contributes to democratic resilience by providing structured, non-violent avenues for dispute resolution. Non-violent avenues for dispute resolution. We used to think once upon a time, go to court. But no, the world is thinking differently now. I can tell you, there's parts of West Africa that are now codifying their tribal law, how they do business. Tribal elders are being actually part of the law now. So think about it. What we have here is an opportunity, really. An opportunity to humanize justice. ADR can be more responsive to cultural and relational dynamics than adversarial litigation. There are critics that argue ADR may shift disputes away from public scrutiny and limit jurisprudential development. Also, litigation generates public law and vindicates civil rights. Settlement sacrifices precedent. It privatizes justice at the expense of public goods. These are criticisms of ADR. They interpret and develop the law. ADR produces none of this. Maybe so. ADR may disadvantage minorities. Sometimes you get an imbalance in power. And the argument is that the bigger company comes in and is able to bully. But my experience has been in mediation, the field is leveled. A skilled mediator is able to allow the parties, I don't care if there's 50 lawyers on one side, everybody gets their chance to say what they need to say. We talked about power imbalances. There you go. Balancing efficiency and accountability. The challenge is to balance flexibility with accountability to ensure ADR strengthens rather than undermines the rule of law. Private arbitral awards are not democratically accountable. Their reasoning is really scrutinized. This is fundamentally at odds with the rule of law value of transparent, reasoned decision making. So it balances efficiency and accountability. Properly structured oversights ensure ADR complements our constitutional principles. Safeguards in Jamaican commercial arbitration include limited judicial intervention only on narrow grounds like public policy violations or procedural unfairness under the 2017 Act, and strong enforcement mechanisms by the New York Convention. Ongoing reforms, such as modernizing legislation to align with UNCITRAL standards, establishing, this is another word you should know about, JAIAC, J-A-I-A-C, for institutional support, and promoting ADR nationally balance party autonomy with protections for the public interest. Commercial arbitration in Jamaica upholds contractual autonomy as a cornerstone, allowing parties to freely choose their arbitrators, governing law, procedures, seat, and rules, and it's reflected in the Arbitration Act of 2017. Excuse me. Now, how does ADR sustain the rule of law? Social stability is significantly enhanced through ADR. These mechanisms, like mediation and RJ, focus on de-escalating conflict, reducing violence, and strengthening community cohesion. By providing structured, non-adversarial processes, such as facilitated dialogue, victim-offender mediation, or circle conferencing, these approaches address underlying tensions. Early prevent underlying tensions and prevent escalation into physical or criminal harm, and it also promotes mutual understanding rather than retribution. RJ in particular empowers affected parties to participate in repairing harm. Overall, integrating ADR into justice systems contributes to safer, more cohesive societies by shifting them from punitive to restorative outcomes, and it lowers recidivism and reducing court burdens, and supports long-term social peace and resilience. This is what we're trying to get to. A lasting peace, a lasting effect, something that can withstand time. Further, it provides economic stability, strengthened through effective ADR mechanisms, particularly arbitration and mediation, which deliver predictable commercial outcomes. It boosts investor confidence and it reduces risk of business. If we bring all these elements together and look at the various sectors of our society, that is from the building blocks to our national output, we can get a better understanding of how conflict is managed within our society. So let's take a very quick look at conflict management in our school, communities, legal systems, and trade and commerce. In our schools, we have the SSP program. Does anybody know what that is? The SSP program is a school suspension program. We have a program that's administered by the DRF, which basically says if a school is in the program, when children are suspended from school, don't just send them home. If they've got issues, send them to us. We start to look at them, see how they're handling conflict with some of those issues. If it's a daddy or mother issue, the right parties are contacted and we try and resolve them. And we have a very high success rate of reintegrating them back into the school society. And most of those children become mentors to the other children. They come back after school. And you'll be surprised. I mean, some of these kids come in and they've got weapons on them. No, we have some serious issues. But fortunately, the program is an award-winning program and it is now replicated in Trinidad. Of course, we talked about community mediations. Most communities have different types of community mediation facilities, victim support units. They have community RJ communities as well. The Ministry of Justice in hand in hand with the Dispute Resolution Foundation actually assisting these communities and trains facilitators. And of course this leads to social stability, de-escalation of conflict, reduced violence and community cohesion. Miss Wisdom? My. We're good back there. Thank you. We talked about our community's home life. Remember, children are the building blocks of our society, and they form the communities as well. So we've got ADR in the schools, we've got ADR in the communities as well, and we have ADR in our legal system. So as you can see, it has to be an attack on dispute resolution. It's not just one size that fits all. And if you start teaching children about how to resolve their disputes, they're going to adults who handle things a bit different. So how can it be accessed in Jamaica? To the DRF, to the Supreme Court, to the Parish Court. You can get dispute resolution mechanism used, mediation, arbitration, restorative justice is access to the Ministry of Justice, but all of these things are mechanisms that are available to our society. Now this is important. How many of you have heard of the UN 2030 vision? No? Need to Google that as well. The United Nations 2030 ADR goals. The Agenda for Sustainable Development does not have specific ADR goals, but strongly supports ADR, such as mediation, arbitration, and other non-court processes as a vital tool for achieving sustainable development. Look at Goal 16, it promotes peaceful and inclusive societies for sustainable development. So, the reality is this: you're not going to meet these goals if you don't have ADR mechanisms. And you're going to see that, and I want you to take that in your journey this week, looking at climate change, law of the sea. How are we going to tackle this? Are the courts prepared to deal with this? Or do we have to deal with them differently? So I'll submit to you that, in concluding, ADR enhances access, it strengthens legitimacy, it supports economic stability, and it sustains the rule of law. You are our future. Dispute resolution is growing, it's evolving. In some jurisdictions, for instance Singapore, their mediation arbitration arm is in the same building. When there's an issue, a mediation or an arbitration that can be mediated, they immediately take the brief down the end of the corridor. And it is taken care of. And if the other things need to come back to arbitration, it's brought back to the other area. Jurisdictions are really evolving throughout the world, and we here in Jamaica and the Caribbean region have a lot to offer. Our 35 years of experience bodes well for us, and it's something we ought to be proud of. But I thank you all for listening to me this afternoon. I don't mind entertaining questions and discussing it a bit further if you so desire. But it's been a pleasure for me to be here. Thank you. Questions? No.
Thank you so much for that informative presentation. And I commend you for thinking about law students' fee for the training, but I will also recommend that we extend it to the bar less than a year, or a year to the bar. If you could think about that.
Yeah.
Think about extending it to students who are attorneys that is a year at the bar.
Okay.
Or less.
I will certainly do that.
Another thing too, ADR. I've seen where it's in the community, but I'm not seeing it in the workforce, the workplace. And it would be good if the Dispute Resolution Foundation could reach out to employers or companies, whether it be on some form of retainer or so, where that whenever there's a dispute within the workforce, they reach out to the DRF, where a mediator is sent immediately, and it's also income for the DRF. Thank you.
Thank you so much. That's a very good suggestion. What the DRF does do now, though, is that they work with like Grace, and I don't mind saying these names, Flow, Digital, and train their senior managers in dispute resolution techniques. But the point that you're making is really a good point. I'm going to take it on board and speak to them about it. Thank you so much, Clover. Clover, right? Clover, yeah? Thank you. Anybody else?
All right, afternoon again. I was just curious, do you have any data as to the success of matters that are referred from the court to mediation? Because remember, we're speaking earlier of it resolving so that it doesn't have to go through. Do you have any data that you can share with us?
I can, yes. At the parish court level, up to the last quarter, you had like an 88% success rate. At the Supreme Court level, it's a little bit lower, 70%, and that's being resolved in a 3-hour period. Now, those numbers are skewed, and I'll tell you why. Because many people come to mediation, and they say it's not settled in the 3-hour period, but they'll leave there. And when they realize their court date or their trial date is 2 years down the road, they will say to their attorney, reach out to the other side, see if their offer is still on the table. And it gets resolved. But the mediator won't get the credit because it's gone to the gate already. That's why dispute resolution has to be looked at in its entirety. And how we are collecting data needs to be changed a bit. Now, no one's talked about AI. AI? Can AI assist us in mediation? What do you think? Yes? No? All right, I hear yes, of course I hear no. Let me mediate that, huh? To some extent. So you're in the middle, all right. Why do you say no? Right?
No, I said yes.
You said yes. Oh, why do you say no?
I said no because for mediation it's a more personal interaction, and it is what you get out of the conversation that you can now encourage some sort of resolution. So for me personally, AI is not not the human element, and you need a human element to kind of resolve these challenges. So that's why I said no.
Okay. Clover?
Well, I'm saying yes because AI is an enhancement. It's artificial, it's intelligence. And yes, it supports our human element. So, I mean, you have that human elements, and as you know, computer is what you put in is what you get out in junk. But if you can utilize how you reach your disputants with AI, it can help as much as possible. You can use it even, those YouTube videos, those TikTok, enhance it, play a little video to share around how you deal with disputes and stuff like that. Because currently there is one going around with the workplace is Veronica, and it's reaching a lot. I mean, I don't appreciate most of what Veronica does, but it still reaches the popular.
Okay, thank you so much for that input. And who's in the middle again? It was my friend over here. All right. And why do you say in some cases?
You're in the middle ground.
I'm in the middle, but I don't mind.
Good day, everyone. So I said it assists to some extent because artificial intelligence is just that, it's artificial. Just to strengthen the point that was made, what you put in is what you get out, right? So AI is a research tool, right? So in mediation, let's say you have a matter that you don't know how to handle, you can auto research to assist you in, reaching a resolution in the matter. So it assists to some extent because it still does require the human element.
Okay, excellent. And you're probably all right. Why? Yeah, well, you are all right. Why do I say that? AI is being used in mediations now. But how is it being used? If you have an international mediation that has volumes of affidavits and witnesses, all kinds of things inside there, AI takes it and sorts it in such a way that it will say to you, there are some areas that they can meet for some sort of resolution. And it suggests to you. And why I say you're right too is because AI cannot produce the human algorithm. So you could be in the room and it could be something that causes you to see, smell, whatever it is, right? And think, oh, there's an opportunity here. So AI can assist you, and it does assist you. In fact, I was sharing with a group last year, but I saw an AI, I was invited to an AI presentation in Singapore, and there were about 12 or 15 of us in the room, and this is amazing. Every 15 minutes it gets a little information. What it does, it provides opportunities, and it speaks like a human being too. So, I was in the room and it asked this particular instrument, I'll call her that, because it's a lady's voice. And she said, they asked her, would Mr. Trump be a good mediator? And you heard this thing, thinking, and she said, well, based on the present qualities we're observing, we don't think that'll be a strong point at this point in time. so I mean, it's amazing. But the point of the matter, it's exactly that, it's a tool. Don't get lazy with it. It cannot replace us. I think that's it. Any other questions? And I know we moved into mediation quite a bit and arbitration, but it seems to be these are soft skills, and you'll see them in your journey of ADR. You'll see that they pop up all the time: arbitration, mediation, RJ, meet up, meet.
Is it that conciliation is only for ILO?
No, but it's often used.
For ILO.
Yeah.
We're law students here. What advice can you give us for us to contribute to ADR going forward?
I think that we have a unique opportunity for a number of reasons. ADR is evolving at a very quick rate, and the attorneys that are coming, you attorneys coming out into the field, have the opportunity of not just coming out to hear about it, but being apostles coming out with it and saying to your clients, there's a possibility that we can get this resolved quite quickly for you. So you become dispute resolvers as opposed to just trying to, be attorneys, so to speak. And these are things that you ought to take into consideration. There are many jurisdictions in the world now that you can get sanctioned if they find that you haven't offered it to your client first. Yes.
All right, so good evening, Mr. Bassie. A question that I would like to ask, because as it concerns some of the attorneys in practice who I believe may contribute or prohibit the use of a ADR tool or a mechanism, what would you say to an attorney in practice? Is it plus for them opting the mediation or ADR or RG option as against taking the matter to court and getting the 5 years worth of fees?
Okay. I said it years ago, and actually a very good friend of mine, very senior attorney, said, oh no, that's not true. I said, well, think about it. When you prepare for mediation representing your party, you have to know your case. It's not just going in there and letting the party speak. Know your case. See where there's an opportunity for your client to come out with a just solution. And in doing that sort of preparation, you will earn fees. It's not just a matter of going in there and just sitting down. You've got to be able to guide your clients accordingly. Show them what it is that they can possibly get. Understand what their high level, their threshold is, what they're willing to do, what's their bottom line. These are things that you've got to take time to sort out. And I do believe when you approach ADR in the proper way, mediation proper way, not only will your clients be satisfied, you get their things resolved better, they remain clients to you, they talk about you too. They recognize what you've done for them, as opposed to 2-3 years later looking at you sideways, are we not going to get to trial and that sort of thing. You try your best to assist them. But like I said, very important, there's a place for litigation, very, very important.
And what about the potential litigator who wants their day in court? What do you say to the member of the public who says, but I've come this far, I really want the judge to hear me?
Well, ensure you get your instructions in writing. You've heard that phrase, right? Get your instructions in writing, very important. Ensure that you do your checklist. You do realize that, that it's not a slam dunk case, or the possibilities is there that you may not win the case. There are costs involved. And once they understand that, and they've said it, full speed ahead. It's their right, their constitutional right. Wow. Thank you. Thank you so much.
Thank you, Mr. John Bassie, attorney at law, barrister at law, for that enlightening and informative presentation. And at this time, I'll ask a final year law student to give the vote of thanks from Group J.
Good afternoon again, everyone. All right, well, first and foremost, I would like to express our heartfelt gratitude to our esteemed guest speaker, Mr. John Bassie, for sharing your valuable insights on conflict resolution and alternative dispute resolution. I extend my sincere thanks to our principal, Dr. Malcolm, Mrs. Wisdom Barnett, Ms. Dion Cruikshank, and the organizing team for their constant support and guidance in making this event a success. A special appreciation goes out to the participants who contributed and could not be here today. Your efforts today would not have been possible without your efforts. I would also like to thank the audience who actively participated and encouraged our meaningful discussions. And with gratitude in our hearts and appreciation for everyone involved, we'd like to thank you for coming today.